For nearly a decade, Victoria Lures has been fighting to save her home from shoreline erosion. She challenged an outright prohibition against protective bulkheads. While her case wound its way through 7 appeals, Ms. Lures lost nearly a third of the land between her home and a shoreline bluff, but the tides are changing. On September 21, 2009, Division 1 of Washington Court of Appeals vacated the county's decision to prohibit her application for a bulkhead. The court restored one of Ms. Lures' most basic rights, the right to show that she is entitled to protect her home.
The Court of Appeals has just ruled in a case that Pacific Legal Foundation has fought on behalf of a Whatcom County property owner. Can you explain what the court said?
Yes, the Court of Appeals vacated prior decisions holding that the property owner's application to install rocks at the toe of her eroding bluff was prohibited as a matter of law. In so holding, the courts decided that Ms. Lures must be given the opportunity to demonstrate that the rock armoring that she had proposed to install is necessary to protect her home. If she makes this showing, then the county must grant her permission to install a shore defense work. Local governments shall provide for methods which achieve effective and timely protection against loss or damage to single-family residences and appurtenant structures due to shoreline erosion.
How long has this battle been going on for?
In total, Ms. Lures has been in litigation with the county on this issue for 9 years. There have been 7 separate appeals. PLF got involved 3 years ago and has represented her in the last 3 appeals.
What does the court's decision mean for Vicki Lures and other coastal landowners like her?
Well, for Vicki Lures, it means that she can finally show what all the experts have said all along, that the rock armor at the toe of her bluff is absolutely necessary to protect her property from loss due to shoreline erosion. And as a matter of fact, while this case has been pending, her home has been damaged, the foundation's been cracked, her walls are cracking. Now she can finally get the protection that's needed. For other shoreline property owners, we hope that this case will say that they will not have to go through a decade of litigation to show the most basic facts that they're entitled to shore protection.
So what's next in this legal battle?
What's next is that Ms. Lures gets to go back to the trial court to show the evidence that supported her application for a shore defense work in the first place. Multiple experts have submitted reports saying that it's not a matter of if the shoreline erosion is going to take her home. It's a matter of when. And that's not a basis to deny or to prohibit shore protection. Every landowner in Washington, by virtue of their citizenship, has the fundamental right to acquire and hold property and to protect and defend the same.